So Rangnath sir has just joined us. I think, can we start the session, sir? It's almost 6:03. If you agree, we'll start the session.
I am in your hands.
All right. Okay. A very good evening. A warm welcome to all of you to the webinar series hosted by Advocates Association, Bengaluru. This evening, we have with us today a young, energetic lawyer who will run us through the applicability of the applicability of Civil Procedure Code with the Commercial Codes Act from the procedural perspective. Mr. Nandakumar, we are elated to have you with us. Before we move on with today's session, I would like to give a brief introduction of the speaker. In fact, I tried to cut down the profile, but nevertheless, it is running around 2 pages. Mr. K Nandakumar completed his BA LLB honors from National Law School of India, University, Bengaluru. He is among those few lawyers who have been exposed to both corporate and litigation practice. His major practice areas covers commercial law, civil law, company law, intellectual property law, arbitration, and corporate insolvency law. He is routinely briefed by other law firms to appear for them. He regularly appears before the Supreme Court of India, High Court of Karnataka, National Company Law Tribunal, and other forums. He also accepts appointments on arbitration. He is a fellow of the Chartered Institute of Arbitrators, United Kingdom. He is a certified arbitrator of the Asian International Arbitration Center at Kuala Lumpur. He is a contributing editor of C.R. Datta, Commentary on the Company Law, 2017 edition. He is also a guest faculty at the National Law School of India, University, Bangalore. During his free time, he loves watching movies, reading books, and listening to music. He's also a wildlife nature enthusiast and loves trekking. It's a very brief profile, which I've cut short to 2 pages. So, sir, I heartily welcome you to this session. Before we go ahead with the session, I would like to make a small announcement. Your question and answer boxes are open, so you can share your questions with us. So before we end the session, we have our speaker who would be addressing those questions. Some of the relevant questions would be picked up. Let me make it very clear. All right. So over to you, sir. Thank you.
Thank you for that generous introduction, Trivikram. Respected President, Mr. Ranganath, and esteemed members of the bar. My intention today is to try and share some thoughts on the interplay between the CPC as we know it and the civil courts as we know it and the commercial courts and the Commercial Courts Act, and see where there is to some extent some deviation from the regular civil procedure that we know, and where there are certain nuances that have been brought in, some specialized aspects of procedure that have been brought in, just to sort of try and see how this is this working better, is this not working better, some questions like that. And I'm sure there are many practitioners out there who've been regularly appearing both in the commercial court as well as in the regular civil courts. So the interaction with the audience, I'm sure, will only make us much richer. Very quickly, we know that it was started as an ordinance and then subsequently there was a legislative enactment. The Commercial Courts Act does something that the CPC does not do. Now, the CPC did not constitute courts because there were already some pre-existing courts, and it also applies to courts which have been constituted hence. Whereas the Commercial Courts Act specifically constitutes certain courts. Now, why is this important? This is important because what the Commercial Courts Act seeks to essentially do is to constitute a new set of courts, but essentially intermingle that with the existing civil procedure structure or the civil court structure. It is not try to bring about a parallel mechanism. Now, we are aware that there are more and more legislations where there are specialized tribunals or bodies that are constituted. This is not really such an intention. This is a case where, with the existing framework, some more modalities are added, certain procedural nuances have been added, and the idea is to make this an expedited procedure for commercial matters. Now, the first question somebody may ask is, why should there be such a specialized forum available for commercial matters? Why are commercial matters important? I think the idea is simple. The idea is that, and this is also the prevailing principle with the insolvency code. The idea is that when there is free flow of capital, that's when the economy will thrive. What has happened on account of litigation being locked up in courts for a long time is that the free flow of capital for commercial matters, suppose I've rendered services or I've sold goods and I'm unable to recover the money, and that is stuck in courts for a long period of time. That kind of a scenario really creates a bit of a cash flow crisis in the economy. The idea was to fast track that. There were some law commission recommendations and so on, but I'm not going to bother going into that at this stage because it's really a bit of a tangent from what we have to discuss. Now, the question therefore is, what is the procedure that should apply when it comes to commercial courts and commercial court proceedings? Now, I will primarily try and answer that, but before that, there are a few salient features of the Act that I'll go into. The first one is the definition of what a commercial dispute is, and this is a very interesting point. Now, what the Act does is to set out a large number of variety of disputes, like disputes arising out of aviation, ordinary banker and merchant transactions, import and export, carriage of goods, franchising agreements, joint venture agreements, shareholder disputes, and so many other mercantile agencies, partnership agreements, and so on. It also has a slightly, I would say, a vast array of disputes or agreements that come into its purview. The principle is that from out of all of these are all matters that are relatable to general commerce, and therefore all of these one should have the benefit of having a commercial dispute. Now, on the question of what is a commercial dispute, we had a recent judgment of the Supreme Court, co-authored by Justice Bopanna, I might add, in Ambalal Sarabhai's case. Unfortunately, I don't have the report reference, but it's the appeal number is available. Again, this is quite an interesting case where Justice Bopanna makes a very interesting observation. So the question was whether a dispute that tangentially arose out of a mortgage would fall within a commercial dispute or not, and consequently would it be within the Commercial Courts Act or not. Now, one observation that Justice Bopanna makes is very interesting. He says that the idea is not that, look, obviously everybody who's a plaintiff, or most people who are plaintiffs at least, would want that their disputes are heard quickly and that they go out of the system quickly. Now, the Commercial Courts Act provides this expedited procedure. Now, what Justice Bopanna says, interestingly, is that the idea is not that the regular court system is unavailable. That is very much available. That one should not be clogging the commercial court system for what is not otherwise a commercial dispute. And this is again fortified by the concurring opinion of Justice Bhanumati, where again she goes into several aspects of the Commercial Courts Act to conclude that there are certain kinds of disputes that are best left to the regular civil courts, and that this is meant, for want of a better phrase, some kind of an exclusive club for commercial disputes and for commercial disputes alone. Now, at this stage, I'll just quickly go into some other aspects of the Act, which are salient, just to sort of give you a quick summary. Section 3, 4, and 5 deal with the constitution of the commercial courts and the commercial division courts and so on. There are also appellate remedies available within this. One thing that did happen was in 2018, there was an amendment brought to the Act. And this is an interesting dichotomy. I think sometimes we are sitting in Bangalore, we just assume that the rest of the world functions in much the same way as we do. But that's not quite true. If you look at, say, the Bombay High Court, Madras High Court, Calcutta, Delhi, and I think the Himachal High Court, where they have original jurisdiction for civil suits and ordinary suits, what happens is that if you have, an ordinary civil suit in the first instance would have gone there. Now, of course, there are some changes and there is a city civil court in most of these places. But if that is so, then by creating a commercial court at the district level, it was leading to some kind of a dichotomy. So that has been ironed out under the amendment. and that is no longer much of an issue. They've really thought through that. And strictly speaking, it's possible to have a commercial appellate division at the district level. Therefore, what has also happened is that there is a concept where of specified value that has been introduced in the Act. What the specified value does is that you may have a commercial dispute, but the subject matter of the dispute, insofar as valuation is concerned, should be of a value of what is notified. Now, the limit originally was 1 crore, but it's been brought down to 3 lakhs. But the government could notify a higher value than 3 lakhs. Now, what this does is that in some places, it's possible that you have a commercial dispute which falls within the definitions that are set out here, but the value is lower. In that case, you might not be eligible to approach the district court also. For example, in Bangalore, we have a pecuniary limit for what comes into, rather in Karnataka, we have a pecuniary limit of what can come at the district court level and what should go to what used to be referred to the junior division courts. Now, that bifurcation has been borne in mind. So therefore, there is a commercial appellate division possible at the district court level. And technically, therefore, it's possible to have a second appeal, Section 100 appeal, also arising out of a commercial matter. So really, the reason I'm pointing this out is that this is not meant as a substitute to the original Civil Procedure Code. The Commercial Courts Act is not a code unto itself like the CPC is. It really has substituted some parts of the CPC for commercial disputes, where insofar as commercial disputes are concerned, there are some additional procedures or different procedures from a regular civil suit. This is really in substance what the object of the code is. Also, like I said, the principle is that there is an expedited procedure whereby the proceedings that are under before the commercial court go on in a much quicker manner. Now, the answer to the question that we were asking originally lies in Section 16 of the Commercial Courts Act. What Section 16 says is essentially that the CPC applies, but along with the amendments that are set out in the Commercial Courts Act. And where there is a commercial court, this is the procedure that is to be followed. Also, it makes it clear that where there is any conflict between the CPC or possibly a state amendment. Now, we are all aware that each state high court has its own amendments to the CPC. Now, where there is a conflict between that and the amendments to the CPC as prescribed under the Commercial Courts Act, the amendments as prescribed under the Commercial Courts Act would apply, and that will prevail. This is really the substance of what Section 16 says. Again, I go back to the example of the Bombay High Court or the Madras High Court, both of which have original side rules on how the suits that are filed there are to be conducted. Now, if there is a conflict between that and the commercial court procedure, again, the commercial court procedure would apply. Now, this is something that one has to bear in mind. To a lesser extent, perhaps in Bangalore, where we are just so used to the city civil court and an appeal going to the High Court. Now, after the definitions, especially of the specified value and of the definition of what is a commercial dispute, there are a few other aspects that are important. The first thing is that one has to look at Section 6 of the Commercial Courts Act, which deals with the jurisdiction of a commercial court. Now, very interestingly, the commercial court has the jurisdiction to try all suits and applications relating to a commercial dispute of a specified value arising within the territory for which that court has territorial jurisdiction. Now, again, the principles in sections 16 to 20 of the CPC are made applicable for the determination of jurisdiction. But what is interesting here is that unlike in some other statutes, there is no bar on the jurisdiction of a regular civil court for commercial disputes. Now, I'll just explain this a little more as we go further, because there is a provision in Section 11 where there is a bar on some jurisdiction, but that is not the bar on, now I'll just give an example of, say, SARFACI, where there is a bar on the jurisdiction of a civil court. What Section 11 of the Commercial Courts Act says is that if the jurisdiction of a regular civil court is barred by any law, for example, the SARFACI Act, then the jurisdiction of the commercial court also stands barred insofar as those proceedings are concerned. Now, in the case of a SARFACI Act, this definition might well come into play. It may be a commercial dispute. So therefore, what Section 11 is trying to do is to say, look, while under Section 6, it is a commercial dispute of a specified value and the commercial court has jurisdiction, the jurisdiction of a civil court, if otherwise barred, even the commercial court's jurisdiction stands barred. But the point I was making was different. In a special statute like the SARFACI Act, the jurisdiction of a civil court is generally barred. In other words, you cannot have filed a civil suit. Now, this does not, the commercial court does not say that if it is a commercial dispute, the jurisdiction of a civil court is otherwise barred. Or it is only that where the jurisdiction of the civil court is barred by a separate statute, that bar also follows insofar as a commercial suit is concerned. So this is not a parallel proceeding. The reason I bring this up is, suppose you in fact have a commercial dispute, and despite the provisions of section 15 relating to the transfer of cases, such a transfer has not taken place. The question is it if the civil court proceeds and passes a decree, the question is it a legitimate decree or is it a decree that's lacking in jurisdiction? I would submit that it would not be a decree that's lacking in jurisdiction, because there is no express bar on the jurisdiction of a civil court to try a commercial dispute. All that the section 15, section 11 and 6 do is to facilitate the trial of such suits which are of commercial nature and of a specified value to be tried by the commercial court. So therefore, this is not really dichotomous, but I would submit that they proceed in parallel with one another. It is not that they are, a substitute for one another. Now, having pointed this out, I'll quickly refer to section 15. I might come back in a minute to a couple of other provisions like section 8, but I'll do that in a minute. Section 15 is something that many of us have actually seen in action. Of course, I think in Karnataka, though the act came into force, it took a little while for the courts to be constituted, the commercial courts to be constituted and notified. Now, what happens under this is that all pending suits, including those relating to arbitration or applications, all of these were transferred to the commercial courts, which are of a commercial nature. It also specifically said in subsection 3, and this is important, that where the suit has proceeded to some extent, then after the transfer, the provisions of the commercial court from there on, that is from that stage onwards, would apply. Now, the idea was not to set the clock back and to have a fresh start from the beginning of the suit. So suppose the suits were transferred to the stage of evidence, it's only the proceedings or the provisions of the commercial court from the stage of evidence that would commence. Suppose they were transferred to the stage of framing of issues, then that is where it would commence. Suppose it's at the stage of arguments, then really many of the provisions of the Commercial Court Act would not apply at all, but it will simply be heard and disposed of by the learned commercial judge. So also, it specifically provided that where a matter was reserved for judgment, then such a case should not be transferred. Now, quite interestingly, what happens if there is a dispute or a question over which court has jurisdiction? Is it the regular civil court or if it is the commercial court? Now, the answer lies in part in subsection 5 to section 15, which says that if there is no procedure for transfer contemplated, so therefore it's presumably the principal judge in the exercise of administrative powers that would effect such a transfer by passing a general notification or an individual notification. But subsection 5 of section 15 essentially says that where there is no transfer that has occurred and the matter really is a commercial matter, then the parties could apply to the commercial appellate division of the High Court, which could then effect a transfer like as if it were a transfer petition from the regular civil court to the commercial court. Now, in this context, it's useful to look at couple of other provisions. One is Section 8 of the Commercial Court Act, and the second is Section 12, subsection 3. Both are very interesting. What Section 8 says is that there is a bar against revision applications or petitions against an interlocutory order. So essentially, if there is an interlocutory order passed, then you can't file a civil revision petition. Now, there are two clarifications to this. One is that an appeal to the extent that is provided for under Order 43 is still permissible. And this is set out in a subsequent provision, which is in Section 13. So unfortunately, the provisions are slightly confusing because one has to go forward and backward. And I can see Mr. Prashant Chandra smiling because I know that he's authoring a book on this. But yes, so the provisions, one has to go forward and backward a bit. That's really why I'm doing it. It's not out of choice or to give you any additional trouble. Section 12, subsection 3 is again quite interesting. No appeal or civil revision shall lie under Section 115 from an order of the Commercial Division, including on a question of a finding on the jurisdiction of whether it's a commercial dispute or not. So I'll just pause here for a minute. Suppose the question comes up as to whether a particular dispute is a commercial dispute and therefore the commercial court has jurisdiction or no jurisdiction. Then a regular civil revision is not permissible because it is barred both under Section 12(3), even if it's a question of jurisdiction, where otherwise 115 revision would have been applicable. It is also barred under Section 8. But interestingly, there is a judgment which says that this does not bar the filing of a 227 writ. I mean, lawyers are ingenious and we don't make our bread and butter without that ingenuity. So this judgment is in the state of Gujarat versus Union of India case, subject to being corrected, where it says that a 227 is still permissible and one cannot take away the right under a 227 writ. And in fact, that's the conclusion that they come back to say that, and interestingly, a similar fact scenario emerged before Justice Bopanna's, in the judgment I mentioned, authored by Justice Bopanna, where again the matter came up from a 227, where the question was whether or not it is in fact a commercial dispute. Now, this is something that, like I said, one has to go up forward and backward in the act a little bit, but otherwise the intention is really to expedite the procedure, and to that extent I think a lot of positive developments in the act. I will quickly complete the portion relating to appeal so that we don't have to revisit that. I mentioned earlier that a civil revision is barred, but that does not bar an appeal that may lie. For example, in a commercial suit, if an injunction application is either granted or denied, your regular appeal, which you would have filed as an MFA previously, if it is applicable, that is under Order 43, that appeal still lies. There is no difficulty whatsoever. Now, therefore, for example, a receivership application in a partnership suit, such an appeal, because Order 40 Rule 1 application, also there is an MFA available earlier. Order 43 comes into play, therefore the appeal is saved under the proviso to Section 13, subsection 1, capital A. So therefore that is something that gives us some benefits. So it's not as if appeals are altogether done away with. And in this context, I want to make up another observation. If you look at the scheme of the Arbitration Conciliation Act, in fact, there is very little remedy available against an interlocutory order passed by, say, an arbitrator. Justice Arun Kumar, in his observation in GBP versus Patel Engineering, in one observation, I think at para 42, if I'm not mistaken, says that even if you suffer an order, an interim order, you have to wait and challenge that along with the main award. You don't have a remedy of taking that in a writ petition to the High Court, and he calls upon High Courts not to entertain such proceedings. So this, the idea is to bring in some kind of a mechanism that is similar to that, except where you have a right of an appeal, or you have to go under a 227. 227, of course, the scope is limited, and therefore the idea is that you should not, the commercial court should not otherwise just for the asking, there be a revision filed and a stay granted by the High Court. So that is really the intention behind this provision. Now, I'll just move quickly to a few other very important and interesting provisions. I know I'm sort of running out of time, so to that extent, I'll just keep this brief. A couple of provisions which are very interesting and important. One is section 18, 21, and 21A. Now, these are the powers relating to rules to be framed. Who has to frame it? Now, this question, insofar as the CPC is concerned, is, we know that it's under section 122 onwards, the High Court has the power to frame rules, and the High Courts routinely have been exercising that power. But here, the High Court under section 18 has the power to issue what is called a practice direction to supplement the provisions of the CPC. Under 21, this act has overriding power, and 21 capital A gives the power to frame rules to the central government. So to some extent, this is a deviation from the regular practice in the CPC. Now, I'll quickly turn to some of the amendments made to the CPC, and this is really quite vital. Unfortunately, I'll be running through them somewhat quickly because I know we are running behind the clock. The first important provision, which also has a ripple effect, is the amendment to section 26 itself, which provides that, before I go into that, I just want to make one observation. For those who have not had a chance to go back to and look at the CPC after the amendments pursuant to the Commercial Courts Act, what has happened is quite interesting. The regular provision of the CPC generally remains, but there is a separate caption which says that this is applicable for a commercial dispute, or this is applicable for commercial court of specified value. And then the amendment as suggested by the Commercial Court Act is also introduced. So if you see, for example, Order 11, you will find that there is an Order 11 that's applicable to plain vanilla cases, and then there is an Order 11 with a complete Order 11 that applies to commercial cases. So in some cases, there is actually a duplication of provisions, one set which applies to regular civil disputes and one set that applies to commercial disputes. This is again quite interesting and unique, and to be honest, I have not come across another statute which does this. But be that as it may, I'll just quickly move on to a few provisions which are quite important. The first is section 26, as I mentioned. The introduction here is that, and the plaintiff will have to be proven along with an affidavit in the form that's prescribed in Order 6, Rule 15, capital A. And the form that's prescribed is a statement of truth affidavit, which once, time and time again, you'll come across when you're doing a commercial matter. I'll point that out in some detail so quickly later on. Insofar as the next important amendment is concerned, that is in section 35. What section 35 for commercial courts does is to substitute the existing section 35. Now, therefore, for your regular civil suit, section 35 as it previously existed still applies. For a commercial suit or a matter before the commercial division, the substituted section 35 would apply. Very interestingly, section 35 is very much analogous to section 31 capital A of the Arbitration Conciliation Act, which introduces a new regime of costs. I'd like to draw your attention to one illustration here, which in subsection 2 of section 35 for the commercial courts application, which deals with one of the factors that the court has to bear in mind while deciding the computation of costs. Okay, this is that in a case of a money decree for breach of contract and damages, where the court holds the plaintiff is entitled to the money decree, but finds that the claim for damages is frivolous and vexatious. In such a circumstance, the court may impose costs on the plaintiff, despite the plaintiff being the successful party, though the normal rule is that the successful party gets awarded costs. So this means that in a commercial suit, if one is approaching the commercial court, one has to be very careful. Please evaluate your case well. Please discuss this well with your client. And unless you have a sporting client, please don't venture and file a suit which is not really tenable, on the basis of documentary evidence and possibly some moral evidence. Now, the next important amendment is to the time limits insofar as filing of written statements are concerned. Order 5 Rule 1 and Order 8 Rule 1 both have been amended. In the regular civil procedure code, the time limit is 30 plus 60 is 90 days. But ironically, in the commercial code, it's 30 plus 90, 120 days. Now, one may ask the question, I thought the idea was to expedite the procedure and not to delay it. The answer is that at 120 days or at the end of the 120th day, if the defendant has not filed the written statement, you completely forfeit your right to file the defense. And that is it. And there's, I think, a judgment where Justice Nariman has held that is the end of the road for you. And, if automatically a decree is passed thereafter, that is perfectly fine. Whereas in the regular civil court, you can go beg and plead, go to the High Court. I mean, I think many of us have done it, so I shouldn't say much more and embarrass myself and everybody else. And so therefore, that kind of an avenue is not available at all. At 120 days, the heart stops and that's it. And that's something that you have to be very careful of. Order 6, Rule 3A is the next important change, which prescribes the form of pleadings, but it also says that the High Court should release practice directions. This has not happened to the best of my knowledge, and I'm ready to be corrected. So this is something that I think if it is done, it would be a useful process forward. Order 6, Rule 15A, I was telling you about the verification. It now has to be by what is called a statement of truth in the form of an affidavit. This is important because this is not only for a plaint, because it speaks of verification of pleadings. So please remember, even if you're appearing for the defendant, in your written statement, you will have to do the exact same thing. And if you don't, your written statement can actually be struck off. And that's actually pretty serious. So you have to be very careful. Or subsection 5 or sub rule 5 says that the court may strike off a pleading which is not verified in the manner that's prescribed. Importantly, in the commercial court amendments to the CPC, there are multiple provisions which enable a judge to strike out your entire evidence affidavit or to strike out parts of your evidence affidavit that he does not think are, that he thinks are argumentative, he or she thinks are argumentative, he or she thinks are not supported by the statement of truth. The learned judge can simply strike out those portions. So all of us who have been used to a lifetime of copying the plaint and making the change into first person, please beware, those days are gone. You better think carefully about how you've got to do this. The next important point when it comes to a money suit typically would be insofar as interest is concerned, where now in the pleading one has to state the computation of the interest, rate of interest, start date, end date. So perhaps it's useful, just a thought that I'm sharing, it's useful to probably towards the later part of the plaint, before we talk about the cause of action and so on, to actually have a column on interest and specifically set out all the details there, just to avoid just to avoid falling foul of this provision. And this is something that I think we must all bear in mind. Then comes the the issue of denial, and this is again quite interesting. Now we know that the CPC talks about how the denial should be. It should be specific. It should do a bunch of things. But the amendments under the Commercial Courts Act have taken it to a couple of steps further ahead. What I mean by that is that specifically, if you look at sub-rule 2 of, please pardon my repeated reference to the provisions, Order 8, Rule 3, capital A, sub-rule 2, 4, and 5 are vital. If you deny an allegation in the plaint, you really need to say why it's denied. If you say that a court does not have jurisdiction, you must actually say which court has jurisdiction. If you say that the the valuation of the plaint is wrong, the amendment to the Commercial Court, the Commercial Court Act amendment to the CPC requires you to say what the valuation ought to be. So it doesn't really stop with, it really challenges the defendant as well to say, all right, you're saying this is wrong. You're saying the plaintiff is wrong. You please come and tell us what is correct. So this is, a slightly higher bar than what we are used to. I know that perhaps there are among the audience some of our learned opponents in many cases. Please bear in mind that this is an academic exercise, and I hope you don't use this against me in any pending proceeding. But I'm just saying as a general caution that this is the extent to which one has to be careful while drafting pleadings. I think for way too long we've all been too used to a slightly more lax system of pleadings because we've not been challenged. Now, I then move quickly to Order 11, which, as far as commercial courts are concerned, has been completely substituted. This is very interesting. What it does is quite remarkable. I must say that they've tried to bring in many of the best practices from international arbitration. I know the Delhi High Court had some practices which are very good and robust. They basically try to codify some of those and bring it into one place, and which is also expedited. The first thing to remember in all of these procedures, and which I'm going to quickly take you through, is that these are not like we are used to in the civil court to say, okay, the matter today stands posted for hearing on IA1 for injunction. We will complete that. Thereafter, I'll post it for list of witnesses. I'm sorry, it doesn't work like that anymore. Because when you file a suit under the commercial court, one has to, and the plaintiff shall file a list of all documents and photocopies that are in his possession or control. If not in possession or control, who is in possession, who has control over it. All of this needs to be stated, and you have to file an affidavit saying what documents are in your possession, what are not. Importantly, we are again far used to filing applications under Order 7 Rule 14 or 8 Rule 1 Sub Rule 3 and filing documents at the last minute. They say, oh, I forgot, I found it in our suitcase. I mean, it was lost, somebody was hospitalized, all of this. I mean, I think judges also just literally start giving up. And I must add here that there were judgments of the High Court which said that you should not generally refuse a plaintiff who's coming at a belated stage with a document. Whereas the table has turned under the Commercial Courts Act. And if you look at Sub Rule 5 of Order 11 Rule 1, a plaintiff shall not be allowed to rely on documents which were in the plaintiff's power, possession, etc., except when leave is granted by the court. Now, we are yet to see enough judgments on this to know how this will be interpreted, but presumably these will be interpreted a lot more strictly than the regular civil procedure practices were. Order 11 Sub Rule 2 deals with interrogatories, both for production of documents as well as for statements and on answers and affidavit. Then, this is what I was pointing out, that merely because your case is listed for hearing on an application does not mean that you should not proceed further with the other proceedings under Order 11. For example, if you are required to complete your process of interrogatories, you must do it in parallel. If you are required to conduct inspection under Sub Rule 3, it has to be done within 30 days of the filing of the written statement. Now, the written statement may have been filed and there may be some other application pending for hearing. Irrespective of that, this process has to continue. So also Sub Rule 4, which deals with admission and denial of documents, that has to be done within 15 days of the inspection. It doesn't matter that there is some other application being heard in court. Independent of that, this should go on, and that is really what is contemplated under Order 11. So really, in many ways, this is, I would say, as good, if not better than international practice, even at commercial arbitrations, where we see how many of these things are fast-tracked and done quickly. There are provisions for production where you can call upon the other side to produce documents. But there is one rule which I'd like to bring to your attention, which is important. Rule 7 speaks of Order 13 Rule 1, Order 7 Rule 14, and Order 8 Rule 1A of the CPC not being applicable to commercial suits. This is important to commercial courts. This is important because what it essentially does is that it takes away your right to produce a document at a later stage unless you follow the procedure contemplated under Order 11. So therefore, my submission here would be that if one is looking to file a suit under the commercial court, or which may be of a commercial nature, please do the exercise of compiling all the documents in advance and get everything ready before you go and file, under the assumption that you're going in for trial straight away. Because I think for, again, far too long, we've been used to filing a suit today, worrying about trial 1 year later, 2 years later, issues frame agli amal nodana anta. But unfortunately, that luxury is no longer available to us. I will then take, I know I'm almost out of my speaking time, but I'll take 2-3 minutes and go through one very interesting provision, which is Order 13 capital A on summary judgment. This is quite a fascinating provision, and I think it's quite useful. It also has enough checks and balances to make it a provision which can be used well. What it does is that between the stage of the court issuing summons and the summons having been served on the defendant, and the stage that the court frames issues, either party, it could be the plaintiff or the defendant, could apply to the court for what is called a summary judgment. What this means is that you compile, and there are a certain set of steps that one has to go through. One has to compile all the documents that are necessary, pose all the questions that are necessary. For example, you'll have to frame the issues that arise for consideration, any points of law. You will have to make out the case that there is no real prospect for either the plaintiff or the defendant, as the case may be, to succeed. And that there is also no other compelling reason why the claim should not be disposed of before recording oral evidence. Now, suppose you have a suit which is entirely based on the interpretation of a contract, and there are a few letters, maybe a couple of notices. Really speaking, what oral evidence will add value to it? I think it's time that we as lawyers think long and hard about using such a practice, using such a mechanism. This is a great mechanism that's available. Very often parties just want to be rid of the process of a litigation as quickly as they can and have clarity as to where they stand. There may be a genuine difference of opinion, and this procedure can really help in sorting out such a difference of opinion. Also, for example, I recall an instance where almost about 12 or 13 years ago, I had an arbitration proceeding before, with most respect, Senior Justice Malimat. And I want to say that we realized that it turned on the interpretation of one provision of law and of two provisions of the contract. He had the foresight back then, before the amendments to the Arbitration Act, before your Balco judgment, before these amendments, to say, look, why do you need oral evidence? Why don't you both agree, file a memo or whatever it is? I'll proceed to hear the main matter and dispose it off. Believe you me, from the time of the first hearing, till I'm talking about the time before the claim statement was filed, till the time we got an award, we were done in four months and a week, or 4 months and 2 weeks. That is the power that this kind of a provision contains. The parties can thrash out their differences and be done with it very, very quickly in a particular given case. I'm sorry, I really don't think I have the time to go through the specifics of this of the procedure that's contemplated, but I just also want to make a few more quick observations, so I will do that. The provision under the summary procedure is not quite the same as a summary suit procedure that is already in existence under the CPC. That is a much more, I would say, a timid procedure, because under the summary procedure contemplated under Order 13 Rule capital A, Order 13 capital A, it has the power, it gives the judge the power to say, yes, I agree with you in part. Suppose you bring 3 prayers. He may say yes to 2 prayers and no to 1 prayer. He may allow one part of the application. He may allow the application conditionally and direct the defendant to deposit some money. All of these options are available within. This is not really the flexibility that is available under the summary procedure that was already in existence in the CPC. I'll then quickly move to what is called the case management hearing. This is again a fascinating procedure, again borrowed from best practices in international arbitration and an excellent mechanism. What it does is it basically puts parties and lawyers on notice that, look, please get on with the proceeding, don't delay. It contemplates the time limit for completion of the proceedings. It contemplates recording of evidence, oral evidence where it's necessary on a day-to-day basis. It also has powers to consolidate proceedings. Suppose there are 3 suits between the parties. The judge need not wait for an application by any party. He need not wait for orders from the principal judge. He has the power to consolidate proceedings, which is again something that we see in arbitration proceedings. He has the power to strike off any witness he thinks is unnecessary. Order a separate trial on a particular issue. So suppose one issue is going to take a longer period of time, he can segregate that issue and deal with the rest of the suit. Many, many such things. Again, there's a reiteration of the rejection of evidence containing irrelevant, inadmissible, and argumentative material. So, I mean, I make this caution to myself as much as I make it to all my brothers and sisters out there who are listening. We have to be far more careful in how we draft. We have to be far more careful in not just converting a plaint to a written statement. I think the seniors would keep telling us that, we did not have computers, we had only typewriters and we could not do this then. I think it's useful to go back to that era of typewriters and reinvent the wheel than try to just blindly copy paste. Couple of other things very quickly, and this is again one very interesting aspect. Under the mechanism of the commercial court proceeding, one has to now there's an amendment to Order 18 of the CPC, where one has to file written submissions 4 weeks prior to the oral arguments. I mean, it may not strictly be 4 weeks because, I mean, in practice, what we've seen in Bangalore and a few other courts is that they are happy to receive it within a couple of weeks earlier. But also after, now here the problem can be, unlike in the CPC, which said that before you complete the oral arguments, you have to file written arguments. Here, it speaks of the written arguments being filed clearly prior to the oral arguments. Now, one additional point here is that if you file the written arguments first, the question that may arise, and in fact, yesterday one of my friends was pointing this out, is that you don't know what the other side is going to argue. So there is actually a chance of a rebuttal that is given. You could file a supplementary or an amended written submission, at a later point, but before the completion of the hearing. So it is not as if you are completely blindsided. The idea is to give the judge a chance to read the relevant papers and come to court so that the hearings are also shortened. I mean, I'm reminded of hearings in many other countries where you are given a time slot of 3:30, come and you complete at 4 o'clock. Or in Australia, where the council are called upon to agree on the issues to be decided before the hearing. These are all mechanisms that we can use and use without really, affecting our practice, but to only boost our practice. So therefore, I think these are quite useful for us to look at. Again, there are further provisions in Order 18 and 19 which deal with the court's ability to control evidence, to redact evidence, to reject evidence. So these are all aspects that have to be borne in mind. I meant to go over a few judgments, but I don't think I have the time. So I'll just pause here. If there are any questions, I'll be happy to take them. And I'm sorry it was so rushed because there is just so much to cover here. Thank you so much. Over to you, Trivikram.
It was not a rush. In fact, a very comprehensive presentation. In fact, you have taken us through the entire act and provisions of CPC. Very informative, in fact.
Thank you.
And Mr. Akash, request you to unmute all the viewers. So if they have questions, they can shoot. Prashant Chandra already has raised the hand. Mr.
That was
Akash,
the one I'm worried about.
Themselves and start asking questions.
Mr. Akash.
Yeah, it is unmuted.
I don't see Mr. I think they have to unmute it.
You may have to unmute.
Yes.
Yeah.
Yes.
No, not a. Mr. Nandakumar, wonderful job you have done.
Thank you,
in
sir.
45 minutes. Now the question is, you are used to playing 5-day test matches as advocates. Now can we immediately start playing 2020 in commercial courts? Are we equipped to do that?
Thank you, sir. I mean, I spoke to Mr. Prashant Chandra yesterday and I was saying that I'm going to make a request to the organizers to bar him from asking a question, but he's asked a very gentle question, the gentleman that he is. I think the answer is that, we are going through changes that we did not expect. Now, if you look at the lockdown and how the courts are now functioning, we have to make changes because this is absolutely an imperative. I don't think we have the luxury of saying whether can we make those changes or not. But I think in a manner of speaking, the amendment having been done only to commercial disputes is a blessing in disguise, because if we are able to make the change in commercial disputes and we are able to apply ourselves with these expedited procedures, then perhaps we would want as the bar to apply those procedures to other civil proceedings as well. And I think that will come both from the bar and the bench, that this is a far better way to deal with many disputes. So therefore, I would say that in many ways, this is a practice match with commercial disputes. And after we succeed in the practice match, or maybe this is a 3-day match, we will then try and do all matches in a similar pattern.
So what you're saying is the bar members have to raise their bar now.
I think absolutely. I mean, I think this is, let's look at, if you remember, and I'm sure you do, because many of the other members of the bar may not have been, they might have still been in college then. When the amendments to the CPC came about, there was a lot of resistance from the bar. But we do know that it has, quickened trials considerably. the amendments made to issuance of process and notice, amendments made to recording of evidence, these have definitely expedited the disposal of cases. Now, I am also conscious, and I mean, I think this is a very important point you make. I don't think speed should be at the cost of justice. I don't think speed should be at the cost of, getting the parties a satisfaction of having had their day in court. But there are mechanisms that are available which safeguard that. And I would say that it is up to us to try and, as a collective, see if we can embrace that change. And the truth is that there are a lot of questions that are asked about why there are so many delays in courts. And these are, I would submit, some effective answers, if not a comprehensive and a complete answer. It is the beginning to make a good answer. And also, I think it's important to remember the context in which this enactment was brought about, which is the World Bank Index on Ease of Doing Business and Enforceability of Contracts. India was, extraordinarily at the end of the queue, totally not commensurate to the size of the economy. Whereas now we have moved several notches ahead. Now, I'm not saying it is only because of this, but having said that, these are all steps that all of us must collectively take. And this is one venture or one step in that direction is what I would submit.
Sorry, I'm taking a little more time. I'm only trying to say, as advocates, we have to plan our trial and procedures in commercial court right at the time of filing wakalat or plaintiff.
Yes.
We can't delay it.
Yeah, I think that is clearly the message that the Act at least gives us. Now, we have had some challenges insofar as logistics. Perhaps, I think, fortunately, we had, two learned judges who were able to cope with the workload. But hopefully we have, in fact, the Act also contemplates training of judges. I would go one step further. It should also contemplate training of practitioners, where we are also enlightened about many of these procedures and we can thereafter come better prepared for cases.
Sorry, one additional information which I am giving you.
Please, sir.
Eight courts are going to be formed as commercial courts by the High Court of Karnataka in Bangalore. And all these 8 courts are going to be in the BSNL complex next to the GPO.
Okay.
So probably if that COVID had not happened, it would have started by now.
No, that's
our members be ready for that now. 8 courts are going to be exclusively for commercial.
That will be wonderful. I mean, and even something like a video conference hearing, certainly there are so many more things that can be done to make things quicker, safer, faster, and at the same time without losing the justice delivery that is the most vital aspect of this whole thing. I mean, I think speed is fine, but not at that cost. So therefore, that is something that I think it still seeks to achieve. Sorry, so someone else had a... Trivikram, I think Mr. Satyanarayana Gupta has a question. Perhaps if
yes.
You
sir, this is Maithili.
Maithili, I think before Mr. Satyanarayana Gupta, a very senior member of the bar, he has a question. And post that you can be ready.
Sure, sir. I'll take up my question later.
Yes, sir. Learned speaker, I'm highly obliged to hear your lecture on the subject. In fact, Mr. Prashant Chandra had highlighted few things with me with regard to the subject. Then, please highlight with regard to the court fee payable on the suits. Court fee payable.
Right. So basically, there is one limited change, but otherwise no change in the applicability of the Karnataka Court Fees Act. So as far as the valuation and court fee is concerned, you still have to go under the, I mean, suppose you make a claim for 1 crore, you have to pay court fees of 2,57,125 as does everybody else. The only difference is in how that specified value is determined to see whether it's a commercial, whether it falls before the commercial court or not. That's really the only determination. And that is set out in Section 12 of the Commercial Courts Act. And there it again goes by the market value of the property or the market value of the movables or the money or whatever it is. So really speaking, as far as court fee is concerned, there is no change. The Court Fees and Suits Valuation Act applies on all fours to this to any proceeding under the under the Commercial Courts Act. Even if it's a counterclaim, the same principle applies. There is no change there.
Thank you.
Thank you, sir.
Maithili, you can go ahead.
Hello, sir. That was a very nice webinar that you gave on the CPC and commercial courts. So my question is specifically with respect to the procedure followed in commercial courts. So you're supposed to, have a pre-mediation file, and then you're supposed to have mediation between the parties. And if in case nothing turns up, then you come to the court.
Yes.
But, unfortunately, we see a lot of lawyers who avoid pre-mediation, before the court, before court proceedings, just so that they can profit out of, out of the misery of the party, so that they can come to court and they can drag the issue and get some money. So is there any way how we can change this? Because Commercial Courts Act was introduced to, cut down the time period and get the issues resolved as soon as possible. And they've made a process for this, but I don't think this is being followed. So any suggestions to improve this scenario?
Yeah, thank you for that, Maithili. That's an excellent question. And unfortunately, again, pre-institution mediation is something I wanted to touch upon, but I completely ran out of time. I think this is a great example of how time management should be better. And I mean, I would only start with my own example. But be that as it may, let me just quickly tell you what the requirement is. Now, if the suit is one only for money and there is no interim relief sought, then one has to go under 12A, section 12 capital A, and go into this pre-institution mediation and settlement, because otherwise there is a bar on the filing of a suit. So suppose you have just a plain vanilla money suit, you can't file it till you exhaust this remedy. This is the first point. Now, obviously, very many lawyers, and you're right in saying, in order to avoid the mediation process, may tactically choose to move some application. Suppose I file a money suit and I want to file an application for injunction, nobody can stop me. The learned judge may reject it. I think really speaking, the regime is that if the learned judge thinks that the application was frivolous, he has the power to ask you to go back, finish that procedure and come back, or to impose costs on that frivolous application. These are the two things that the learned judge has the power to do. But there is one other important aspect that I would bring to your attention, which is that if you look at the second proviso 2 subsection 3, it talks about the period that parties remain occupied in the mediation, they would be exempt from limitation. But please remember that merely the filing of the pre-institution mediation request is not tantamount to filing of a suit. Therefore, unlike in the case of a suit by an indigent person, where the day you file the application as an indigent person along with the suit, your date of the limitation clock stops ticking. That is not so. Suppose the mediation fails, thereafter the suit would have to be formally instituted. So therefore, there may be a gap there one has to be careful about. It's possible that in some cases where the limitation is really towards the fag end, one may not want to resort to this. I can understand that. But otherwise, I would only say that if more of these expedited mechanisms are used and the bar becomes more aware of these practices, it would be, the bar members would be more welcome to go into mediation. I'll give you one example. If you think about the scenario about 8 years ago, when we did not have this arbitration center in Bangalore, or maybe 10 years ago, when maybe a little more, when we did not have the mediation center in Nyaya Degula, people were just not aware of mediation or arbitration, and they were very wary of it, and naturally so. Lawyers would think that if I go into mediation, I may lose my fee. But those misconceptions have now gone, and we have senior mediators sitting in the audience today. So with those misconceptions having gone, I would only submit that it's a progressive remedy where it will take a little more time before people realize that it is really not a bad thing. The minute I issue a pre-institution mediation, and maybe the other side will come and settle. I'm happy to tell you 2-3 of our cases have gotten settled even before the suit was filed. Now, if I've saved the client the trouble of getting a court fee DD, filing it, collecting that, filing the suit and all of that headache, and I just get the remedy at this stage, I would like to think that the client comes back to me for another matter as well. And I think that's probably the progressive way in which I'm sure the bar members would react in time to come.
In fact,
Thank you, sir. Thank you. I think you've answered my query. Thank you.
Thank you so much.
in fact, Friday's subject matter of the webinar is pre-trial proceedings under CPC.
Right.
Mr. D.R. Ravishankar is addressing. Any more questions, learned members? Somebody has any question? You can
I think
shoot.
Mr. Rangarajan has a question. He was there.
Yes, sir. Please go ahead. Mr. Akash, I think they are not able to.
You should be able to unmute.
Mr. Rangarajan, you will have to unmute your. Sir, please, you will have to unmute and you can speak.
I have one minute.
Yes, sir. I can hear you now, sir. Please. Oh, no.
You are able to hear me now?
Yes, sir. Please go ahead, sir.
I am Rangarajan. I am an old timer. Now, this question is with reference to section 15 of the Commercial Codes Act. I have a legal case that comes from a rural district. Now, what has happened? Despite the Commercial Codes Act, the case was not transferred by the district court.
Right.
Parties made an application. Are you hearing me?
Yes, sir, I can.
Parties did not make an application requesting the court for transfer. The matter proceeded and ended up in a suit being decreed.
Right.
Now that suit has to be put into execution. Naturally, a question has arisen as to whether such a decree is without jurisdiction or with jurisdiction. You have very rightly pointed out to section 11 and more pertinently section 9 of CPC, etc., etc. Now, to buttress that conclusion, suppose if a matter goes before a court of law on an interpretation of this statute, because the legislature in its wisdom has not provided for a clear-cut provision which takes away or outs the jurisdiction of the civil court from dealing with commercial dispute. Possibly one is the legislative wisdom. Another is even by using the theory of casus omissus, I am very sure no court can come to the conclusion that civil court shall not have the jurisdiction. Therefore, a decree inadvertently passed by a civil court would still be a valid decree.
Absolutely.
Am I correct?
Sir, I share that view. Thank you for that, sir. I actually share that view because there is one additional reason. I mean, you are absolutely right in pointing out the 2 or 3 provisions which support that view. There is one other point, which is that let us assume that you did make an application and you say that the commercial court did not have jurisdiction or the civil court did not have jurisdiction, it should be heard by the commercial court. I think the point is that let's say that the case was reversed. Suppose you filed a regular civil suit before the commercial court. Even if the commercial court comes to the conclusion that it has jurisdiction or no jurisdiction, you can't really wait. I mean, the only option you have is to wait for a decree. So therefore, if it follows to my mind that it's not a situation where this is a decree without jurisdiction. It is simply that you do not have the benefit of being able to approach the commercial court and therefore all the expedited mechanisms that are attributable with that come with it.
Very
but
nice.
Having said that, you've already achieved your end result. You've got the decree, so therefore I don't think it makes any difference.
Now, I wish to raise a very interesting question. Today, somebody filed a suit, civil suit, in a civil court. And can a court pass a decree which is purely commercial in nature? Dispute is commercial in nature. It is filed before the civil court.
Right.
Suppose it fails to transfer it under section 15. Then what happens? Can the civil court continue to?
I think probably 2 things. One is you can take the plea that the court does not have jurisdiction. Secondly, under section 15, subsection 5, you could make an application.
Yes.
Because either party can make an application there. So you could make an application saying that this is either of a commercial nature or not of a commercial nature, as the case may be, and then point it out.
Ultimately, it looks like the civil courts have not lost their jurisdiction.
No,
totally.
they've not. They've not.
They are.
But I would say that this is a subset within the civil court mechanism. So it's not that the civil courts have been shorn of their jurisdiction. That's, I think, the correct conclusion.
I am really happy and thrilled by your exhaustive commentary on the Commercial Courts Act. Thank you very much. Thank you.
I think we have Anandita who has messaged me. So Anandita, you can go ahead. Please unmute and shoot your question. Anandita, can you hear me? Next would be Mr. Abhiroop. If Mr. Abhiroop is ready, I think you can go ahead with the question.
Sir, I am ready, sir. If I may be allowed to go ahead.
Yes. Please go ahead.
Thank you, sir, for such an exhaustive explanation about the Commercial Courts Act. I have a question that is very particular to the time period for filing the written statement of 120 days. So I just have a question. Let's just say, supposing a party has been placed, one of the defendants has been placed ex parte, and then subsequently files an application under Order 9 Rule 7 to set aside that order placing them ex parte. And that application is allowed.
Yeah.
But that application is allowed after the 120-day period has passed. So will that, in such a situation, does the code provide for, I mean, the code obviously, the Commercial Courts Act obviously doesn't provide for a situation like this as far as my understanding of it goes. So is this a deliberate omission, or is this just an oversight, or is there, is there something, because see, again, from my understanding in the regular CPC, once the application is allowed, the court may grant an opportunity to file a written statement.
Correct.
But what happens in this situation if such an application is allowed in the commercial court?
So you are absolutely right. I think this is possibly a gray area, and it's not been addressed specifically under the Commercial Courts Act. But having said that, the answer probably should be that if you look at Section 16, the principle under Order 9 has not been taken away. So therefore, if you move an Order 9 Rule 7 application and ask for the ex parte order being set aside, and if you're able to offer just and sufficient cause, then that order can be set aside. But if you further go one step further, the point is that there is a very clear embargo on the 120-day hard stop. Therefore, there may be two views possible, and I'm yet to come across a judgment. I don't know if there is any other which Mr. Prashant Chandra has come across. There are possibly two views possible. One is that you could move an Order 9 Rule 7 application. That is not barred. But even that would have to be within the 120-day deadline. And unless you get that order set aside within that 120-day deadline, you would probably be out. One way to do it is to show your bona fides by filing the written statement along with that application or whatever it is. I don't know. That is one mechanism to try and explore. The second view is to say that, look, after the Order 9 Rule 7 application is allowed and the order is set aside, placing you ex parte, then your clock starts again. But strictly that may not be a correct view, because if you look at Section 16 again, if there is any sort of inconsistency, the Commercial Courts Act and the stringency would apply. And 120 days is a hard stop. So to my mind, the conjoint reading would be that, yes, suppose you missed the appearance in the suit on the first date, that's fine. But you still have to show enough diligence and show it quickly, in that you appear literally on the very next day, or by advancing the case or whatever else, by making out a case to the court and say, look, I'm ready to file it. Please, I want to do it before the 120th day. I missed that date, whatever happened, the office was locked, pandemic, whatever. But outside of that, please grant me this indulgence. But to my mind, the answer is that even the 9 Rule 7 would have to be within 120 days. I mean, unfortunate as it might sound, it is what it is.
Next, we have Anandita. Anandita, can you hear me?
But this is, yeah, can you hear me?
Yes, please go ahead.
Sir, thank you for the informative presentation, sir.
Thank you.
My question is, if there's a conflict between the CPC and the commercial court procedure, say for
Right.
example, I file a suit for recovery in a summary procedure,
Right.
and the leave to defend of the defendant is
Yeah.
allowed. I, under the CPC, have a right to file a civil revision petition
Correct.
and challenge the same. But
Right.
however, under the Commercial Courts Act, that is clearly barred, like you just explained.
Right.
So what would be applicable and how should one go about?
Okay, the answer is actually slightly tangential, so please pardon me for that. What you are talking about is the traditional summary suit that was contemplated under the Civil Procedure Code.
Yes.
Now, what the Commercial Courts Act has done is to introduce, and I think I'm probably went through this a little quickly, is to introduce this summary judgment procedure.
Yes.
Now, the question, if your question is merely because there is order 13 capital A, has it taken away my right to file a summary suit? Perhaps not. And I don't think that's the point I'm making. But really speaking, if you do that, you run the risk of not being able to file a revision. Therefore,
Okay.
it might be expedient for you to move your application under order 13 capital A, which is much more comprehensive, and you might get a far more complete remedy. For example, in a summary suit proceeding, there are sufficient judgments which say that leave to defend should be given as a matter of right. But that is not quite the case under a summary judgment. So if you are a plaintiff, your preference would almost certainly be order 13 capital A as against proceedings under the summary suit mechanism.
Okay. Thank you, sir. Thanks a lot.
Right.
Mr. Samarth Prakash, you can go ahead. Mr. Samarth? Mr. Samarth?
Yeah.
Yeah. Can you hear me, sir?
Yes, sir. Please go ahead.
Thank you. It's really informative. I have a few queries, sir. With respect to Order 8 Rule 1, you have told there's an outer limit of 120 days. Suppose I do not file it within 120 days, my written statement is not filed within 120 days, and my right to file a written statement is exhausted.
Yeah.
So now in the present situation, in this pandemic times, suppose the 120 days was coming to an end during the lockdown period, then what is my relief?
The answer is quite simple, because if you look at the pandemic period and continuing now, the High Court has declared that this is a period where the courts are closed for the purposes of the Limitation Act.
Okay.
This also takes into account the order passed by the Supreme Court in one writ petition. So therefore, till 7th of July or 6th of July, whatever the date in the notification is, the courts technically and strictly are closed, at least for the purposes of limitation. In fact, only for the purposes of limitation. So therefore, you could not have filed a written statement in that period is a plea certainly that I think would be available to you. But having said that, if you delayed beyond even a day thereafter, you may be in trouble. What may be safe to do is to apply to the learned registrar and get permission to file it electronically or with the registry even before the time period comes to an end. That may be the sensible thing to do.
Perfect. So now to follow up with this.
Yes, please. I can hear you. Please go ahead.
So to follow up, so assuming that the pandemic was not there, my 120 days was exhausted. What about my leave to defend? Would I be, or is it according to the CPC when I cannot ask him, I cannot cross-examine based on my defense?
It's all gone. I mean, your defense is gone. So therefore, if I were the plaintiff, I'd straight away apply for summary judgment, because I don't even need to let in oral evidence. You see, the beauty of summary judgment is that you don't have to go in and put your witness in the witness box at all. You file an application, produce your documents, specifically make a statement that the defendant has not set out any defense, and say, therefore, these are the only 2 points for consideration, and apply for the summary judgment, and the judge almost certainly will pass it. I don't see why the judge will resist in passing it, unless the documents that the plaintiff has filed are insufficient in the learned judge's mind. Then, of course, the learned judge will probably just dismiss the suit. I don't know. The point is that I think you must to that extent step away from the traditional notion of a civil trial where you can say, okay, even if I did not file my defense, do I at least have a right to cross-examine? If I were the plaintiff, I would subvert it by filing an application under, Order 13 capital A and ask for summary judgment. So I don't even get into the witness box. I can see Mr. Sandeep Jindal has a query.
Mr. Sandeep, you can go ahead. And next in line, we have Mr. Prashant Murthy after Mr. Sandeep.
Sorry, you're still on mute.
Can you hear me now?
Yes, please go ahead.
Yeah. Firstly, Mr. Nandakumar, my congratulations for giving us a precise and yet a concise overview of the issues involved. It was informative. I personally was not aware of these couple of judgments that you had referred to. I'll certainly go back and study these judgments. Now, for the moment, I was seeking your view on something interesting that you had stated, and this is what one of the other panelists, Mr. Rangarajan, he had also referred to. This is section 6.
Right.
This is relating to section 6, jurisdiction of commercial court.
Right.
Now, your reading, if I'm not mistaken, is that since there is no express bar of the civil court's jurisdiction, therefore any decree that is to be passed by the civil court, consciously, unconsciously, would be a valid decree. But you're aware of section 9 of the CPC?
Yes.
Where there is a presumption of jurisdiction of civil court, yes, unless there is an express or implied bar.
Right.
Now, if you read section 9 of the CPC along with section 15 provisions,
right,
section 15 of the Commercial Courts Act.
Right.
Section 15(1) speaks of transfer.
Right.
Transfer and the moment of transfer, the time of transfer is critical, is important, I think. Where a commercial division has been constituted. So the moment a commercial division is constituted, the transfer has to be done by the civil court.
Right.
And the language used is shall be transferred.
Right.
So there is no, in my view, there is no discretion vested with the civil court. You will have to transfer. Similar is the position in subsection 2, where the moment a commercial court is constituted, you shall transfer.
Right.
Now, since the language used is preemptory, in the sense that you have to do it.
Right.
So would that amount to an implied bar under section 9?
Right, that's a great question. I mean, and honestly, I don't think we have an answer to that yet, definitively. Until such time that we hear from, Supreme Court judge, unfortunately, you'll have to make do with my view. Now, the point is, I would say that if you please look at subsection 2 of section 15,
okay,
the proviso, it speaks of where the judgment has been reserved by the court. I'm sorry, provided no suit or application where final judgment has been reserved by the court prior to the constitution of the division shall be transferred. Now, to me, what this implies or suggests, but you are right, of course, in saying that it's possible that there's no express bar, but it could be an implied bar, and there is certainly an argument we made there. But having said that, I think this, if you look at this, the proviso to subsection 2, as well as subsection 3, the latter part, which speaks of application of those procedures which are which were not complete at the time of the transfer. To my mind, it is not an ouster of the jurisdiction of the civil court as much as a substitution of the jurisdiction of the civil court. And I'll tell you why I'm making the difference. By ouster, what I mean, or what I would imagine is, of course, in the case of, say, the Sarfacy Act or whatever, there's a specific bar where you say, you cannot file a suit. A civil court cannot entertain it. Whereas that is not the case with this. Here, all it has done is to set up another court and to say for all of these cases, this is where you will go going forward. Now, if I am a litigant, I am not very keen on classifying my case as a commercial case or not as a commercial case. I just filed a suit and I followed the procedure that was then available to me. Now, if the registry has not chosen to classify this as a commercial case and transfer it, can the litigant be penalized on that account? Does it therefore oust the jurisdiction of the civil court fundamentally? I'd respectfully submit that it doesn't. Because to my mind, this is really more akin to, I would say, closer to 7 Rule 10 to some extent. But you're right, even there's an argument to be made about a court lacking in jurisdiction. The point I would still make is that this is not a fundamental lacking of jurisdiction on the part of the civil court. It is simply a substitution of jurisdiction insofar as some cases are concerned. And in certain cases, take for example, you take the Tisasari courts in Delhi or whatever, the number of cases that are filed there are so vast that it's possible that the registry makes a mistake or there is an incorrect classification. In such a case, there can always be some kind of a doubt. And so therefore, I don't think the intention is to oust the jurisdiction of the civil court. It is simply to substitute it with a better mechanism. So the fail-safe would still be the civil court.
Understood. It's a fair enough question. It's a fair enough answer. And just one more point I had to raise. You had also mentioned that the Civil Courts Act, it's not really a substitute, for the regular civil court mechanism. Right. Now, as a lawyer, as a litigator at the grassroots level, the definition of commercial dispute, right, would it include litigations which are ongoing, in the sense that if you look at the definition of commercial dispute, right, subclause 1 speaks of ordinary transactions of merchants, bankers, financiers, etc. So a recovery suit, a money recovery suit filed by a bank,
right,
as long as it is within the specified value,
right,
would that be a commercial dispute under the Commercial Disputes Act? Secondly, if you look at, for example, 20, subclause 20,
right,
insurance and reinsurance.
Right.
Now, for example, if there is an insurance claim or a motor
right,
accidents claim,
right,
motor accidents claim for compensation, right, again, if it satisfies the definition, if it satisfies the specified value, would that be a commercial dispute?
Okay.
That has to be transferred to a commercial court.
Okay. So I think the answer to your question lies in section 11 of the Commercial Courts Act. Now, so here's the way I see it. I would say that there are 3 classes or 3 categories or 3 hoops. The first is where the jurisdiction of the civil court is itself barred. In such a case, you can't go to the you can't go to the civil court, and therefore you can't even go to the commercial court. For example, bank suit. Now, if the bank is to file a recovery case, there is a bar under the RDDB Act or the bar under the SARFACI Act. Therefore, you cannot go to the civil court. So therefore, the jurisdiction of the civil court is fundamentally barred. Now, if the jurisdiction of the civil court is barred, now, or rather, let me put it, in cases where the jurisdiction of the civil court is not barred, this could be my neighbor tried to interfere with my possession, I filed a bare injunction suit. That is not necessarily a commercial matter, so that the regular civil court still has jurisdiction over. A partition suit, 3 warring brothers, regular civil court still has jurisdiction. If it is, like you said, a money dispute, right, or a commercial transactional dispute, then if it falls within the bucket of commercial dispute within the definition of the Commercial Courts Act, then from within the larger ambit of the civil court, you go to a smaller classification of the commercial court. This is the way I see it. The reason I'm also making this point is that if you look at the CPC, it's a very fair statement to make, and I think Supreme Court has said on multiple occasions that it's a complete code unto itself. But that is not so when it comes to the commercial code, the Commercial Courts Act. The Commercial Courts Act is neither a complete code, nor is it meant to be a complete code in itself. So therefore, that's one more reason I make this 3-step classification. The first is where you can't go to the civil court at all. Second is, if you go to the civil court, do you go left and go to the regular civil court, or do you go right and go to the commercial court? I think that's probably my sense of how I look at it. Thank you.
Mr. Prashant Murthy.
Yes, sir. Sir, can you hear me, sir?
Yes, please go ahead, sir.
Yes.
Sir, first of all, thank you so much, sir, for taking your time out from your busy schedule to enlighten us about the nuances of this act.
Thank you so much.
Sir, my question is rather a confusion regarding the retrospectivity or the prospectivity of the provisions of the Commercial Courts Act. Let us say, sir, just prior to the coming into the force, the Commercial Courts Act, my 120-day period to file the written statement has come to an end. Then, by virtue of retrospective application of the Commercial Courts Act, can my substantial right to file a written statement be denuded of?
The answer to your question lies in section 15, subsection 3,
yes, sir,
which says that the provisions of the Act shall apply to those procedures which were not completed at the time of the transfer. So therefore, that's really the answer. If your written statement was not filed and you're literally at the cusp, I would say one more thing here, which is that, you know, we've had the commercial court in Bangalore now for almost a couple of years, a year and a half at least. So that 120 days is well past, at least for Bangalore. I mean, perhaps in a smaller town in, you know, suppose a new commercial court comes up, that may be an argument we made. But by and large, this point in time has already come and gone. So I don't think this complaint can now be made. That's really the way I would look at it, because if it's the provision, I mean, rather, if it's a procedure that was already completed, then that's fine. If it was not completed, what is the remedy you had? You could avail of that remedy at the point in time of the transfer. But now 1.5 years down the line, for you to make that complaint may be a little difficult. Sorry, is there any other question? I'm sorry, I don't know if...
I think that's about it. Mr. Ashok had a question. If not, I request all of you to send offline questions, and I would request Mr. Nandakumar to answer it, because we are running short of time. We have taken his time. It was just for 5 to 10 minutes. I think he has answered for about 30 minutes. So if you have any questions, please send those questions offline. You can message me, you can ping me on WhatsApp. So I would request Mr. Nandakumar to answer it. Mr. Ashok.
Yes. I have few questions, sir. My question is whether
quickly.
I am very happy to see Mr. Nandakumar. I am a junior of Satyanarayana Gupta and Rangarajan. They have spoken to you. The counterclaim is permissible in your system, Commercial Courts Act. Counterclaim is permissible or not?
Yes, sir, it is. The short answer is yes, it is. In fact, even insofar as the determination of the specified value is concerned, you know, the counterclaim comes into play under section 12. It's possible that the counterclaim alone is of a commercial nature and not the claim. So suppose I file a regular bearing injunction suit, you can file any counterclaim. You file a counterclaim which is a commercial matter. Stricto sensu, even that gets transferred. That's really what has been said here. So therefore, certainly a counterclaim is maintainable. Certainly a counterclaim can be entertained, and a counterclaim also comes into the picture when it comes to determining the specified value, which would determine the jurisdiction of where you go, which commercial court you go to. Sorry, any other questions?
I think that's about it, sir.
I can't see any other hands raised. I don't know if I'm making a mistake. Sorry.
But I'm getting a lot of messages, but we are apparently running short of time. So we will have to cut short it there. My apologies for that.
No. I mean, I'm glad this is so interactive. It's what really makes a session worthwhile.
Very true. Very true. Sir, on my personal behalf and on behalf of Advocates Association Bengaluru, I thank you very much for accepting our invitation, for addressing our audience, and also addressing their queries. Thank you so much.
Thank you to the Advocate Association, our beloved President, and Trivikram as well as Prateek. Thank you for the opportunity, and I stood educated myself quite a bit because of this. So it's certainly a two-way street. Thank you so much.
Thank you. Before we end the session, I would like to thank Mr. Akash for his technical support and Mr. Advocate Prateek for offline work that he has done for us, for all of us, in fact. And our own people, of course, President Mr. A.P. Ranganath, Secretary Mr. Gangadraya, Treasurer Shivmurthy, and all other office bearers. I thank them for their continuous support. And thank you so much once again, Mr. Nandakumar. Thank you so much. It was a wonderful session. And
Thanks.
tomorrow you can tune in at the same time, 6 to 7. We have Mr. Murthy Nayak speaking on conundrum of appeal, revision, and 482 petition from criminal procedure court perspective. Thank you so much.
I'll just add this, Trivikram and the others who have organized this. The topics that you've chosen, not only this one as well as the other ones, I hope this was useful, but the other 2-3 topics that you told me about, they're very interesting and fascinating. So my congratulations. You've worked very hard in putting this together. Please accept my congratulations. Very great job done.
Thank you, sir. Thank you so much. Thank you so much. With your permission, I'll be winding up the meeting.
Thank you so much.
Thank you so much once again.